Good morning, ladies and gentlemen. Please be seated. We're back on the record in the matter of the state of Georgia versus Khalif Adams et al. In 22 SC 1835572. Go ahead and take roll for the morning. All right, Mr. Stillwell, Mr. Boston, Mr. Sharp. Good morning, gentlemen. All right, Mr. Williams, Mr. Steele, Mr. Adams, and Ms. Renard. Good morning. All right, Mr. Kendrick and Mr. Weinstein, good morning. Mr. Huey and Mr. Matthews Sr., good morning, sir. All right, Mr. Nichols, Ms. Westmoreland, and Mr. Harvey, good morning. All right, Mr. Ryan and Misty Williams, good morning. All right. Okay, Mr. Uhowski, Mr. Brown, Mr. Atkins, Ms. Love, Ms. Knight, how are you? Good morning. Okay, all right. Okay, Sergeant Brown, all the jurors present?
Yes, sir.
All right. Anything I need to take up before they come out?
I just want to review my motion for severance and my request for 105 instructions with regard to the litany of investigations that investigated Dennis. So I know you have given me.
I continue an objection on those two bases, severance and a 105 instruction. Yes, sir. Okay. Some of our jurors, please. Can we recall our witness too, please?
Mr. Adams.
All right, ladies and gentlemen, please be seated.
All right, Judge, I'll juror present.
All right, thank you, Sergeant Ingram. Good morning, ladies and gentlemen, jury.
Good morning.
All right. Good morning, retired Detective Dennis. Sir, you're still on the oath, okay?
Okay.
All right. Mr. Adams?
Dennis, welcome back, sir.
Good morning.
All right.
Where to start? One of the things you testified to yesterday, maybe the day before, was in regards to your observations of individuals at the compound on the night of April 25th, true?
Yes.
And you mentioned Trontavia Stevens, yes?
Yes.
And let's see, I think you mentioned Jimmy Winfrey as well, right?
Yes.
All right. And you knew these individuals, you recognized some of them from either previous encounters or just hadn't seen them before. Right?
Yes.
Now, one of the people, specifically Jimmy Winfrey, who you knew as Pee-wee or Roscoe, is that right?
Yes.
That individual, that gentleman, you were asked some questions about whether you followed him on, I don't know if it was Instagram, some social media platform. You remember that question?
Yes.
You said you did follow him.
Yes.
You were familiar with him from following him on not just that way, but also from following him on Instagram or, again, whatever platform it was. Yes?
Yes.
And one of the questions that was asked of you was whether you followed him in your capacity as a APD officer or personally. You remember that question?
Yes.
Your response was that you followed him in both capacities.
No.
No? You didn't
I didn't
say-
even have Instagram back in 2015 personally.
What was the social media platform that you followed him on?
Instagram.
Okay. So help me refresh my memory. Didn't you testify earlier, a day or so ago, that you followed him on social media in both your capacity as an APD officer as well as personally?
I couldn't follow him with my personal because I didn't have Instagram, a personal Instagram account at that time.
All right,
So
maybe
I did not say, I don't recall saying that.
you don't recall saying, okay. But you knew him, right?
Yes.
And you knew him personally. When I say personally, you all didn't hang out and go to Buffalo Wild Wings together, but you knew who he was.
Correct.
In fact, so much so that when you saw him that night, you went up and you shook hands with him.
I didn't go up to shake his hand. He came up and shook my hand.
Oh, you all shook hands.
Yes.
Right? There wasn't anything wrong with that.
No.
There wasn't anything wrong with you associating with this person that you knew in whatever capacity, right?
Correct.
You had seen him previously at other venues.
Yes.
You knew that he was someone who was kind of in the, I don't know what, club music industry of some sort. Is that true?
Yes.
Okay. And so you knew that he was either a burgeoning, budding, he was a rapper.
I didn't know that he rapped at the time.
Okay. You came to find out that that was the case.
Yes.
Okay. At the time that you saw him, you knew that he was in whatever form or fashion involved in the music industry, right?
Yes.
Okay. Now, and there's nothing wrong with you shaking his hand, being associated with him or talking to him.
Compound and form about something wrong.
I'll sustain the objection. Just rephrase, Mr. Adams.
Okay. At any rate, when you saw him that night, you interacted with him.
Yes.
Okay. When you saw some of the other individuals you referenced earlier, you either said something to them or interacted with them in some form or fashion.
Yes.
Trontavia Stevens, were you aware whether he was at the compound that night celebrating his birthday?
No clue.
You don't know why he was there.
I didn't.
You don't know why anybody was there.
I did.
There were hundreds of people there at the compound that night.
Yes.
And as you described it I think you described it as even urban or an inner city, maybe you said hood, neighborhood type of establishment, right?
Yes.
Where people come and hang out for whatever reason they want to hang out.
Correct.
Okay. Now, the video that we saw yesterday, I remember I asked you some questions about the halftime video.
Yes.
Okay. Now, you testified that you don't know anything about the makers of that video or the producers or anything like that. Is that true?
Yes.
Okay. Now, you would similarly not know anything about any promotional videos that would have been made to advertise any upcoming appearances or tours for Mr. Williams, would you?
I sustain the objection.
Okay. You were shown a video where Mr. Williams is talking about his coming appearance in Louisiana. Is that right? You remember that?
Yes.
Okay. Now, you're not suggesting that there's anything wrong with someone putting out a promotional video for their upcoming concert, would you?
I sustain the question. You can rephrase.
Are you aware of whether that was a promotional video or not?
It appeared to be.
Okay. Are you aware of whose direction or at whose direction that video was produced?
What do you rephrase? I don't understand what you're asking.
Okay. Do you know whether or not some management of Mr. Williams suggested that the video be made to promote his upcoming appearance in Louisiana?
I don't know.
And that's true. You don't know anything about the inner workings of any productions of any of these videos that have been testified to or shown, right?
When you say the inner workings, what do you mean?
Well, who made them, right?
Correct.
Who suggested they be made, right?
Correct.
For what purpose in regards to his profession they were made, right?
Objection to assuming facts.
I stand.
Well, when we talked yesterday, you recollected or you agreed that Mr. Williams, by the time in 2015, you knew him to be a local, national, international performer. Isn't that true, sir?
Yes.
Okay. Now, one of the things that you were asked about early on was the different people. You remember the video that you were showing with the cars at the vault?
Yes.
Okay. And you were asked to describe those cars and whether you knew, what was happening in the video. Remember that?
Yes.
Okay. I think Mr. Shaw asked this question, but the individual that you saw appear, and when I say the individuals, I'm talking about Stevens, Mr. Winfrey, the other, Mr. Dolly or Dora, whichever one of the young ladies it was.
Mm-hmm.
They showed up at different times at the compound, is that right?
I saw them at different times.
You saw them at different times. You don't know when they showed up?
I don't.
Okay. You described them in a piece of your testimony as Jeffrey Williams's people or something like that. You remember that?
Objection, Your Honor, mischaracterizes testimony.
I stand the objection. You don't need the phrase.
Do you remember how you described them? Do you remember describing them in some form or fashion based on their association with Jeffrey Williams?
Old.
Yes.
Okay. Now, it is true that you know that certainly Jeffrey Williams knows and is associated with his sisters, right?
Say that question again.
You know that Jeffrey Williams, for example, is associated or knows his sisters, right?
Yes.
Right. But the fact is, all of these individuals that you described were there that night. Mr. Williams was not, right?
As an answered objection.
Old.
Right?
Yes.
Okay. And one thing I do want to clarify. You described individuals who were outside of the compound during the course of the night. Remember that?
Yes.
Now, you said there were a lot of people, a big crowd of people, right?
Yes.
There were some people standing on street corner. Yes?
Yes.
Some people standing in line going down the sidewalk, right?
Yes.
There were some people that were moving towards or appeared to be in close proximity to where the tour buses were parked, right?
Yes.
Now, do you recall your police report referencing something like 20 or 25 people? Remember that number in your police report?
If you got a copy of it, I can take a look at it.
Well, let me just ask you if you remember how many people you saw out there that night.
A lot.
Okay. And other than the names that you mentioned, right, you don't know the association between any number of those people out there, do you?
Objection made.
Old objection.
Do you?
I don't know. The ones that I recognized, I know the association between them
Right.
and where I know them from.
Right, but I mean, if you saw 25 to 30 people And you mentioned about what, 5 or 6 different names of people that you knew?
Of the crew, yes.
You don't know the association between those 5 or 6 people and the other, do some math, 21 or 20 people, right?
No,
Or if
but
they were associated at all.
if I'm working and I appear to see a group of people congregating together and it appears that they're together, then one could make the assumption that they're all together.
Right, so if you see 25 people on the street corner, you're gonna associate that all 25 of those people are associated with each other, as opposed to them just being in the same proximity?
That's a strong possibility, but on that night, I saw the people that I recognized and people that I didn't recognize standing together on the same corner.
Right. And so I'm clear, the report that you wrote, that we referenced before, was written about a month or so after the night at the compound. Is that about right?
That's correct.
The night at the compound was April 25th. Your report was maybe May 25th or 26th. That sound about right?
Yes.
Okay. You were asked a lot of questions about different events, right? Remember that little timeline board thing behind you, right?
Yes.
You were asked about those different events. Is it fair to say that in most of those incidents, you were not the person going out personally investigating those? Is that fair to say?
That's not.
No? In a lot of those, there would have been other detectives or police officers who relayed information to you. Is that right?
We worked in a conjunction with other detectives. Usually a patrol officer took the initial report. We would then look into that report and then follow up or correspond with other detectives as we needed to.
Right. And you keep saying we, right? And when you say we, you mean sometimes you, right?
Yes.
Sometimes Detective Gaither, right?
Yes.
Sometimes some other detective, right? Yes?
Yes.
And a lot of times, a lot of the things that you testify to, right, doesn't come from your personal knowledge. It comes from,
Hey, look, when there's objection, stop talking.
well, can I ask a question before she?
If there's an objection, stop talking. I'll give you directions after that. Okay.
Yes, sir.
All right. Basis.
Your Honor, he said a lot of the times, and so this day.
I sustain the objection. You can rephrase, sir.
Okay. Information that you've been asked a lot of times, I think the way it was phrased is, in the course of your investigation. You remember hearing that phrase?
Objection vague, Your Honor.
I sustain the objection.
Well, in the course of the investigation that you've been testifying about, a lot of the information that you got came from hearsay statements from either officers or individuals. Isn't that true?
I sustain the objection.
One moment, please.
Yes, sir. All right.
I may have asked you this question before, but in the event that I didn't, let me go ahead and ask it, all right? Did I hear you correctly that you don't know the time frame between which this Lil Wayne tour bus shooting occurred and the halftime video, when it was released?
I don't know the exact date, no.
Okay. All right, that's all I've got.
All right, sir. Anyone else for examination of this witness? Cross? Okay, any redirect?
Yes, Your Honor. Detective Dennis, you were asked on cross-examination a question by Mr. Sharp regarding seeing Mr. Stillwell at the compound the night of the 20th or the morning of the 26th. Do you remember that?
Yes,
And do you recall saying something akin to, you hoped that he had gone inside and had a good time or something like that?
yes.
Was he one of the people that you were told to keep out?
Objection, Your Honor.
Basis.
Your Honor, this is not hearsay, it is.
I sustain the objection.
Was he one of the people that you were intending to not go into the club to interact with Lil Wayne?
Objection, Your Honor. Still calling.
Your Honor, the instruction,
I sustain Mr. Adams' objection. I'm taking Mr. Short's objection.
on direct examination, did you talk about instructions that you were given regarding what you were supposed to do at the club?
Yes,
I sustain the objection.
When you saw Mr. Stillwell, did you intend to follow or carry out the instructions that you were given as it relates to what was happening inside the club?
Oral, sir.
can you repeat the question?
When you saw Mr. Stillwell, would you tell the jury whether you intended to carry out the instructions you have been given as it related to who to let in or not let in the club?
For myself, I was working traffic, so I wasn't at the entry point into the club. Like I said previously, there are about 15 officers placed throughout the club. My assignment was traffic. The officers at the door would be the ones that would make the decision on who came in or not. That was not for me to make that decision.
And when you were asked on cross-examination by Mr. Adams about following Pee Wee Roscoe, and you talked about separate Instagram accounts that you did not have or did have.
Mhm.
What did you mean when you said you didn't have a personal account? What did you mean?
I had a UC undercover account. I didn't have Instagram myself up until probably recently, so couldn't have followed him personally.
Okay. And when you were asked on direct by me whether you followed him in your capacity as an officer or personally, what then did you mean when you said both?
When I say both, just
Your Honor,
I sustain the objection.
You on cross-examination told Mr. Adams, do you recall, that you did not follow Pee Wee Roscoe in both your personal and official capacity. Do you remember that?
yes.
What did you mean when you said that you did?
What I meant when I said that was just because I follow him, it wasn't like I was following him with the intentions of him breaking the law. I met him when he was young. I've watched him do different things within the music. I'm happy for him. I wish he would have stayed on that track. So at the end of the day, when I follow him, I'm not following him to necessarily build a case or something.
Now, did you encounter Mr. Winfrey at any time after the Lil Wayne bus shooting where he offered you anything?
Yes, at his probation office.
All right. And do you recall around the time of the year that was?
I think that was either Monday or Tuesday following the bus incident.
And what happened at Mr. Winfrey's probation office?
After we located his name, we reached out to his probation officer. His probation officer had him come meet her at the probation office. My partner and myself, in a plainclothes capacity, were there as well. As soon as he saw me, can I curse?
You may say whatever it was that you said. It's not offered for the truth of the matter. It is a pronouncement made to officer at that time, Detective Dennis, that is not being offered for the truth of the matter asserted. The fact that it was made is the evidence that we are tendering.
The fact that it is made is not a proper response to
It
a
is.
hearsay objection, and we don't have any of this information to be on record.
Yeah.
That's a speaking objection. I'm gonna overrule the objection, okay?
Go ahead.
Answer it.
When Mr. Renfrey saw me and my partner sitting there, he said, "Oh, fuck." And he went into his pocket and got it, and he walked up to me and said, "I was tripping the other night." And I looked at my hand and I said, "What's this? I don't get down like that." And he just kind of, "It's cool," or whatever. And at that point, my partner and I looked at each other, knowing what we were there for, like you just pretty much told on yourself.
And what did he put in your hand?
It was $200.
And was it in what form? Do you recall what form it was in?
I believe it was two $200 bills.
And what did you do with the $200?
I put it in a,
Overrule, sir.
Go ahead.
I put it in an evidence envelope and sealed it up and initialed it and put it in my file.
All right.
John, I have may we approach briefly?
Sure. Yes, sir.
Thank you.
We have our witness come back, please.
Would you take attendance, please? Detective Dennis, I'm going to approach you with what has been marked as State's Exhibit 124 Echo. And Your Honor, for the record, the state has cut it open at the bench. Detective Dennis, do you recognize what has been marked as State's Exhibit 124 Echo? Look at both sides.
Yes.
How do you recognize State's Exhibit 124 Echo?
It's an evidence envelope with the case number and my unique ID number on it.
And did you do anything with State's Exhibit 124 Echo back in 2015 as it relates to the Lil Wayne bus shooting incident?
I put Jimmy Pee Wee Winfrey on it, and then I put the evidence marker on it, initialed it, and put the date on it.
And did you seal that envelope up that is labeled State's 124 Echo?
Yes.
Now, do you see, just for the record, that there's a sliver of the envelope that is now disconnected from the main envelope?
Yes.
All right. Was that the way that you left it, or did you leave the envelope fully intact?
Fully intact.
All right. And other than the sliver being cut from the bottom, are there any changes to this envelope from when you sealed it back in 2015?
No.
Your Honor, the state tender State's Exhibit 124 Echo as evidence.
Any further objection to 124 Echo?
No further suggestion in regards to this cover.
Okay, all right. 124 is, Echo is admitted. Objection.
Thank you. Detective Dennis, since we've now cut the bottom out, would you please pull out whatever is in 124 Echo? You turn around and hold it up to the jury. You stand up and tell the jury what you're holding in your hand.
$200.
Two $100 bills?
Yes.
All right. And where did those two $100 bills in the steel envelope from 2015 come from?
Mr. Jimmy Winfrey.
And is there any kind of date on that, those two $100 bills in terms of the date the money was manufactured or anything? Are you able to see that?
It say Series A 2003 at the bottom, I guess.
That's one of them.
Both.
And are there any serial numbers on the bills?
Yes.
What is the serial number of both bills? Just read them in sequence.
One is F as in Frank, L as in Lincoln, 848-707-55, B as in boy. The other is D as in David, F as in Frank, 49037-880, B as in boy.
Thank you. Why did you put those two $100 bills into an envelope and seal it up?
Objection, relevance.
Oh, sir.
Because first off, I was insulted because insult to land for.
Objection, relevance.
Without talking about your insult, is there any reason beyond your feelings of insult that you put those two $100 bills into that envelope?
So we can maintain it and have it as evidence, or just to
Show that it was done?
Objection to the testimony by the prosecutor.
I'll sustain objections to the.
All right, use your words.
Say again?
We'll just strike right.
I'll say, ladies and gentlemen, disregard the last.
To prosecutor's last word.
Prosecutor's last.
In your words, why, beyond your level of insult, Did you put the two $100
so that we have it, and so that it's stated for the record that you can't buy me.
Why did you give it back to him?
Why?
Yes, why?
I don't know. At the time, we were there trying to get the other information and just interview him pretty much, or set up an interview.
You were also asked on cross-examination. Thank you. This is states 124 Echo. I'm gonna put this bottom part in the $100. Yes. For the record, Your Honor, I'm just placing 3 states. You were asked on cross-examination by Mr. Adams about who managed the halftime, I'm sorry, not the halftime video, who may have instructed Jeffrey Williams to do the video where he talked about being in New Orleans or in Hollywood, right? Do you recall that?
Yes.
Just one moment. I'm gonna put back on the screen 117 Echo, which has already been admitted as evidence.
Yeah, YSL. Carter 6 coming out Friday, first show. New Orleans, Holly Grove. Fuck, nigga. Yeah, YSL. Carter 6 coming out Friday, first show. New Orleans, Holly Grove. Fuck, nigga. Meet me there, better beat me there, you did. Man, with them dicks, too. Yeah.
Now, when you were answering the question about promotional videos by Mr. Adams, is this the one that you were talking about, 117 Echo?
I believe so.
Now, do you know whether that's a promotional video?
No.
Do you know? Oh, I'm sorry. How do you personally know whether this is a promotional video?
Objection has been asked.
Not how, no. You just asked on the cross-exam.
Almost the same phrasing.
Do you recall answering Mr. Adams' question about that being, or whether that 117 Echo is a promotional video? Do you recall answering it? That's all I'm asking.
Yes, I guess.
All right. And do you recall answering, yes, it's a promotional video?
Your Honor, I'm going to object to number one, with the attorney testifying, and the witness's testimony will speak for itself.
Information for the question. Do you recall answering, yes, it was a promotional video, it appeared to be a promotional video?
I don't recall if I answered yes or no.
Okay. Say yes, it's a promotional video. Do you have any personal knowledge? Yeah, that. Okay. So, can you, not saying whatever your speculation is, but can you, from your own personal knowledge, testify truthfully one way or another about whether or not this is a promotional video?
No.
Okay. And can you, through your own personal knowledge, testify truthfully about whether anyone other than Jeffrey Williams told Jeffrey Williams to say what he said in that video?
No.
Objection to the form of the question.
Who was talking in the video?
Jeffrey Williams.
Who?
Jeffrey Williams.
And for the record, does he say anyone told him to say what he says in the video?
No.
And for the record, is there anybody whispering anything in front of him or in there as he's speaking into the video?
Video will speak for itself.
And because the record can't reflect the next question I'm gonna ask him if there's an objection.
Well,
For the record, is there?
That question is speaking. But for the court, I don't know what that is.
Just disregard, I'm going to disregard counsel's statement, ladies and gentlemen. You'll be instructed to say, just state the question.
For the record, is Defendant Williams reading from any piece of paper as the video progresses?
Speculation.
Let me judge. Objection false speculation.
Do you see it again?
Repeat the question again.
For the record, while Mr. Williams, Defendant Jeffrey Williams is speaking on this video, is he reading from any piece of paper?
No.
And do you have any personal knowledge of whether, of anyone instructing people to stand behind Mr. Williams with guns?
No.
But do you see that in the video?
Yes.
And did you all have to do anything special, hack any pages or anything like that, other than go on a public website and find the video? I will rephrase. Did you, as a game detective, have to do anything beyond go on a public webpage to find?
That was, Matthews and Mr.
Did you have to do anything special to find or look at this video? Did you have to enter a password?
No.
Your Honor, they special search.
I'm sorry, did you have to enter a password?
No.
Did you have to dial up any numbers or anything like that, get access to it?
No.
Did you have to turn on your computer
Or phone? Yes.
or phone?
Yes.
Did you have to go on a website?
Yes.
Was the website public?
Yes.
Open?
Yes.
Okay. Did you have to do anything with respect to your law enforcement credentials? Did you have to enter any law enforcement credentials to look at this video?
No.
You were also asked by Mr. Adams about the halftime video that we saw yesterday. Do you recall being asked by Mr. Adams today about the halftime video? Your Honor, we're gonna put up on the screen 118 Echo.
Wait, did you have that? I didn't know it now.
118 Echo was. Would you like for us to make sure before we
Hang tight, yeah.
hang that tape? Yes, I should.
Okay.
Yes, all right. Awesome. All right. On that halftime video, at 3 seconds in, for the record, would you tell the jury what is written on the screen?
Says by Director BLB.
And that's BE space EL space BE.
Correct.
And who is in the framing as that said, as that language is written?
Jeffrey Williams.
Go ahead. And at 11 seconds in, what is written on the screen?
Also directed by Young Thug.
And do you know who
Yes.
who is that?
Jeffrey Williams.
Continue. Did you at any time while watching this halftime video, and let me back up and ask, this video, was it also available publicly?
Yes.
Did you have to put in any special credentials to see this video?
No.
And was it open for anyone to look at?
Yes.
At any time in this video, just for the record, did you see any words, lyrics written by someone else?
No.
Did you see written by someone else?
No.
You were asked. You were asked by Mr. Sharp on yesterday about seeing Shannon Stillwell do certain acts the night or the morning of the 26th of April 2015. Do you recall being asked a series of questions like that by Mr. Sharp?
Yes.
During the time that you were assisting in the investigation of the Lil Wayne bus shooting, did you learn of any?
Objection, Your Honor, calls for hearsay, confrontation clause.
Your Honor, I haven't asked him about what anybody said.
Oh, objection, sir.
Did you learn of any publicly available social media back and forth between Young Thug?
Objection.
And Lil Wayne.
Still facts not in evidence.
I should say that objection.
During your investigation of the Lil Wayne bus shooting, did your investigation reveal any publicly available messages and media
Yes.
between Jeffrey Williams and Lil
Your Honor, I'm
Wayne?
going to object. It's the same question, and it still facts not in
It is
evidence.
not, Your Honor. I'm not.
Also subject to the court's previous ruling.
Your Honor,
I must say.
I investigation, did you determine or make any determinations about the state of the relationship between Jeffrey Williams and Young?
I'm gonna object, and that falls to speculation, and again, it goes to the court's previous ruling.
And Your Honor, asking for a direction, may I approach? Thank you.
Ladies and gentlemen, we've had a request for a bathroom break, so I won't tell you who, but can we take 10 minutes? Okay, all right. Okay, everybody can take 10 minutes, please. All right.
Still, Harvey, Miss D. Williams, there she is. Matthews is not in here.
Okay.
Okay.
Okay, where's Mr. Matthews? See it.
That's true. Oh, there.
You all could gather your thoughts, please. Yes, Mr. Sharp.
Your Honor, thank you. I believe the state will be seeking to
I'm sorry?
They couldn't hear me.
Okay, all right.
I believe that the state will be seeking to admit what is State's Exhibit 123E, which is a video of my client making those comments about the game. You remember what we're discussing?
Yes, sir.
Okay, that was subject to litigation. So first of all, for the record, when you ruled against me a couple days ago, I said, okay, saying I understood the ruling. My learned colleague, Mr. Steele, informed me that that could be confused as acquiescence on the record. So I want to be clear that I am not acquiescing to the playing. I'm maintaining all my prior objections.
You objected and I think
Right.
your objection's been maintained.
Okay, I just didn't want that. Okay.
No, I'm going to admit it over your objection.
Okay.
Or subject to the objections that you've
Okay.
made already.
Thank you.
For purpose of the record.
And the other issue I have, Your Honor, is the video that they're seeking to play is a video that was captured off of social media. The problem is it has the video, which I understand Your Honor is let in, but then it also has this alleged tweet from my client. And I have two issues with that. First, this, to my knowledge, this was not subject to a search warrant or even an investigator going on my client's Twitter page and pulling this tweet.
Was it public?
Well,
Was it public?
it was published, not
Public?
by,
No, I said, is it public?
it is public.
So it was
Well-
obtained from a public site.
Well, but it's obtained from someone at College Kids website or whoever put this social media post up. We have no idea where they got it from. So, I mean, I don't believe that proper authentication.
We've had this discussion before, and that was part of your objection. So I've heard it. I'm still going to overrule it.
Okay, well, and then in the event that you were going to overrule me, my other issue with it is those should be two separate state's exhibits. There should be a video and then there should be a tweet. There should not be a video with a tweet embedded by collegekids.com or whatever the social media website they got it from. Those are two separate pieces of evidence and they should not be displayed together. That's how it was displayed for, I guess, to get clicks on social media. But that's not really how, in my opinion, we should be doing it for trial. Those are two separate pieces of evidence. And so I would object. I would ask that the tweet, if Your Honor is going to find that there is authentication for the tweet, at least it should be removed from that video or darkened out off of that video, and then they can also admit the tweet.
State, the last issue in regards to the video and the tweet.
So it was the defendant's video of him posting and his social media handle, his words. We can make it two separate, but we don't think that there's a need to because he's the one that posted the two together. He being the defendant.
I don't.
And I'm not sure if Mr. Shard is speaking of the one where we had the long tweet after.
I don't believe what the state said. I don't believe it to be true. Because this is a professionally curated thing where they have the video and a tweet on top of it, and I'm sure the state can play it. But to my knowledge, I don't even know if my client is a person who posted that video, but also to my knowledge, there's no evidence that my client released to the public a video of himself with a tweet of allegedly of him tweeting as part of the same digital media. I think that was done professionally by whoever owns collegekids.com. And, you know, collegekids.com is not really the entity that should be preparing the evidence for this case. And if it's two different pieces of evidence, they should be presented separately.
All right. If that's all you have at this point in time, Mr. Shar, is that it? I'm gonna,
That's it. And all my prior objections.
I'm gonna overrule your objection, okay? All right,
I understand.
all right. Can we, get our witness, please?
Before that occurs, Stacey showed us a while ago what they marked as Stacey Exhibit 125 Echo, which purports to be items that we discussed with the court previously. They are videos of Mr. Williams. The first one, recognized, we discussed that has Mr. Williams talking. The second one also has Mr. Williams talking. There's a third one, and these are all stitched together as one video. Goes from one into the next, into the other. I don't know how they put it together, but the third one appears to be Mr. depiction of Mr. Williams rapping over a Future's a rap artist, song. And I don't believe, and maybe I can be correct, but I don't believe that last image or video has been litigated in regards to this admissibility. I recall the first two, and the court ruled on those. We said those two can be admitted over our objection, but I do not have a recollection if we've actually addressed that third one. Obviously, my position would be that I oppose it. I object to it for all of the same objections that we made in regards to the other two videos. But unless I can be corrected, I don't believe there's been any adjudication, any ruling on that third one that they've put together as part of Stacey Exhibit 125E.
And Your Honor, just to keep things moving, we don't have to, and we will not at this time attempt to tender that portion of this video for those reasons, just to not have it something that holds things up. So for the record, the exhibit number will be Stacey Exhibit 125 Echo. The first 9 seconds, the first 31 seconds of Stacey Exhibit 125 Echo are the exhibit that we've just played for the jury, that is 117 Echo. And the second portion is a total of 16 seconds through 31 seconds, which is the part that Mr. Adams is speaking of. And what we will do, therefore, is not play the last part that he says has not been litigated.
All right.
It's not just that I say it, it has not
What?
been litigated.
Okay, that has not been litigated. I'm not meaning to mince words. We won't play it. We won't play it at this time. We won't tender it. We won't try to publish it. We won't do anything with it.
All right.
For those reasons, to keep
Okay.
it moving.
All right, sir. Summon our jurors, please. And get our witness, if you wouldn't mind. Thank you. Please be seated.
I'll just bring the counsel.
All right, thank you, Sergeant Ingram. All right, Ms. Love, you can continue.
Detective Dennis.
It's not on.
Okay, I'm not. Okay.
No, you can turn it off. I just said, you want to listen to that?
Thank you. It can go off. Detective Dennis, are you aware of social media posts by defendant Williams relating to the album that, or the mixtape that he was set to release during the time of the Lil Wayne bus shooting?
Yes.
I'm going to show you State's Exhibit 125 Echo. And Your Honor, this is from the timestamps, 16 seconds to timestamp 31 seconds for the record. Making sure it's all good. So from 16 seconds to.
Before you show it, has it been admitted yet?
No, Your Honor, we're not showing it till it's. Not that part, just this one. Is 16 seconds through 31 seconds in State's Exhibit 125 Echo one such video?
Yes.
And are you familiar with the person inside the video?
Yes.
Are you familiar with the person inside the video outside of their depiction in the video?
Yes.
And is the video an accurate reflection and depiction of the person inside the video?
Yes.
Your Honor, the state tenders State's Exhibit 125 Echo from 16 seconds in to 31 seconds in.
Any further objection?
That's down previous objection.
Okay, all right. Subject to the court, previous objections and ruling, the court will admit 16 Echo over objection. It may be published as you see fit.
Thank you, Your Honor, not yet. 125 Echo. He said 16 Echo.
Is it 116 Echo?
125.
125 Echo, okay, all right. I'll correct myself. Thank you. All right.
Detective Dennis, during the time that the Lil Wayne bus shooting happened, did you say that you listened to Lil Wayne's music?
Yes.
Okay. And were you familiar with the series of albums Lil Wayne had released prior to the time that his bus was shot up?
Yes.
Are you able to tell the jury the title of that series?
Carter.
And how did that series show itself? In other words, was it Carter A, Carter B, Carter C, or something?
I'm gonna object.
Basis.
Based on speculation.
He has a person.
I'm gonna sustain the question as to form speculation. You can rephrase.
Thank you. How are you familiar with the series that Lil Wayne released prior to his bus shooting?
Carter 1, 2.
No, don't say it. How are you familiar with the series that he released prior to his bus shooting?
When you say familiar, what do you mean?
How do you know what the series was? Did you listen to it?
I've listened to it. I believe I have it on my playlist. I listened to it.
And did you listen to all of the albums or the tapes in that series that you just mentioned, Carter?
Yes.
So what are the names of each album or release in that series?
The Carter 2, 3, 4, 5.
Okay. So I'm gonna actually, Your Honor, I'm gonna play 1 through 31 of State's Exhibit 125. The first 31 seconds are also contained in State's Exhibit 117 Echo.
Then I'll object as to cumulative.
Overruled, sir.
Okay, you may play.
Yeah, YSL. Carter says coming out Friday, first show. New Orleans, Holly Grove. Fuck, nigga. Meet me there, better beat me there, you did. With them dicks, too, nigga. Yeah. Can't name the mixtape Carter 6, cause these fuck ass niggas trying to sue. Shit like some hoes. Big old blood, so I'm going bar the 6. On the fucking way.
As you stood there directing traffic for Lil Wayne's appearance that night, did you know of any lawsuit regarding Carter 6 and Barber 6?
Yes.
You did, as you stood there directing the traffic?
At that time, yes. It was national news.
And you were asked by Mr. Sharp about seeing his client and seeing what he had done and whether or not you saw him do anything that was of interest to you. Do you remember that?
Yes.
That is not what was asked.
What's your basis for your objection?
The misstatement.
All right, I'll sustain the objection.
Do you remember being asked by Mr. Sharp about Shannon Stillwell?
Yes.
Now, have you also had an occasion to view Mr. Stillwell on social media, public social media, making commentary?
Yes.
All right, I'm going to show you what we have marked as State's Exhibit 123 Echo. Do you recognize the persons depicted in State's Exhibit 123 Echo
Yes.
in the front of the camera?
Yes.
All right. And is this one such public social media posting of Shannon Stillwell?
Yes.
And do you recognize Mr. Stillwell outside of him being depicted in the video?
Yes.
And do you recognize, let me just say, is it a fair and accurate depiction of Mr. Stillwell?
Yes.
Your Honor, at this time, the state tender states Exhibit 123 Echo.
I object authentication, foundation, relevant to all other previous.
All right, and they're noted, Mr. Sharp, and I will admit 125 Echo, 123 Echo over objection. It may be close, it's just.
That same shit that got Biggie and Tupac killed, little fuck, nigga. Pussy ass nigga, get your bitch ass killed. YSL for life. Yeah, can't come that low. Hey, gang, you bring your pussy out down here, you gonna see me. I'm at your fucking neck. Fuck anybody.
Did you recognize Mr. Stillwell in the video?
Yes.
And for the record, where is Mr. Stillwell as we sit looking at the first clip of the video?
The person on the screen in the front of the video.
And the person seated behind Mr. Stillwell and to the right of Mr. Stillwell.
If you
Just a second. Right there. Right. And
Go ahead.
the person depicted on the screen to Mr. Stillwell's behind him, not where the hand is, just behind Mr. Stillwell. Who is that person?
It is Quindarius Zachary.
And is he also YSL?
Yes.
That's at 15 minutes, 15 seconds.
Thank you. And that's at 7 seconds in. At 8 seconds in, the person besides Mr. Stillwell, whose face is shown at 8 seconds in, is that the person you were referring to as Mr. Zachary?
Yes.
At that time that you were out there, did you know anything about the game and any lawsuits between about the barber six or the car six? At the time you stood out
Assuming
there.
facts, not an evidence.
I sustain the objection.
Were you concerned as you stood on the street corner directing traffic at all about the game that night?
No.
And the game, to your knowledge, what is it, just like a basketball game or is it an artist or is it something else?
It's another rap artist.
Another what?
Rap artist.
You were also asked on cross-examination by Mr. Adams about seeing individuals, a group of 20 to 30 people at the compound. You remember that?
Yes.
And when you spoke about seeing your report, would it refresh your memory as to what you said about the 25 or 20 to 30 individuals?
Yes.
I'm gonna object, there's no question asked, but he's indicated he needs his recollection refreshed.
I sustain the objection.
Thank you. Do you recall speaking to the jury about a group of people with Pee Wee and Mr. Zachary?
Yes.
Do you recall saying that they had about 25 to 35 people with them?
Yes.
As you were being asked by Mr. Adams about the association of the people in that group, do you recall that?
Yes.
Are you able to tell the jury why you surmised that Mr. Zachary and Mr. Winfrey had 25 to 30 people with them?
I'm gonna object to form the question and misstates the testimony previously.
I sustain the objection. You can rephrase.
Yes, Your Honor. Do you recall what you reflected in your report about the people with Mr. Zachary and Mr. Winfrey the morning of the 26th?
I can look at my report.
Would looking at your report refresh your memory?
Yes.
Your Honor, the state is approaching with State's Exhibit 113 Echo Romeo.
That already been shown to the defense counsel?
It has.
Okay, all right.
Thank you. just read over it, don't read it out loud, starting at the paragraph where I have my finger. Actually, if I may. Start here. And then read to the end of the page. And if you need to flip over and keep reading, go ahead. Has your memory been refreshed about what you wrote in your report?
Yes,
And Mr. Adams asked you about writing a report in May of 2015. Do you remember that?
yes,
When you wrote the report, were the events of the morning of April 26, 2015 fresher on your mind then than they are today?
yes,
And did you attempt to accurately document what you recall?
yes,
I'm gonna object, these questions been asked and answered.
I'll rule the objection, sir.
Now, having refreshed your memory, can you tell the jury, one, whether you observed and documented that there were about 25 to 30 individuals?
I sustain the objection, Mr. Fulton.
One, whether you observed and documented the number of people who were with Mr. Winfrey and Mr. Zach,
yes.
and what number of people were there?
25 to 30.
And do you recall why it is that you documented that they were all together?
Because at some point I saw them on the corner standing together.
Did they also move together?
To the best of my knowledge, yes.
And did you recognize people in that group besides Mr. Zachary and Mr. Winfrey as members of YSL?
Yes,
And did that group of people at any point begin to walk towards Lil Wayne's tour bus?
yes,
And as that happened, them walking towards Lil Wayne's tour bus, did you all do anything? By you all, I mean you and any other person working with the Atlanta Police Department.
yes. Me and other police officers attempted to disperse and to keep them moving.
And was it before or after that point that you observed the handgun on the wheel well of the greens floor?
Probably after.
Would reading your report refresh your memory?
Yes,
All right. Would you just go ahead and turn to the page beginning of? Right.
Well, that's been asked and answered already. We'll move on.
I can. Thank you.
Thank you.
Let's start that last question. Okay. Did Mr. Sharp ask you about where Shannon Stillwell was on the morning of April 26th. Do you remember him asking you questions about that?
Yes,
Now, were you with Mr. Stillwell before he arrived at the compound with Mr. Garlington and Mr. Stevens?
was I with him?
Yes.
No,
And were you with Mr. Stillwell after he left the compound?
no,
And other than seeing him there at the compound, do you have personal knowledge of all the places that he went the morning of April 26, 2015?
no,
You were asked about a white truck by Mr. Adams and I believe Mr. Sharp. Do you remember that?
yes,
Do you have personal knowledge of who may have been in a white truck at the time of the Little Wayne bus shooting?
no,
And do you have personal knowledge of where any member of YSL, where all they went after they left the compound?
no,
When you were asked by Mr. Adams about the shootings that occurred on the timeline that we have up here, do you recall Mr. Adams asking you whether or not it was true that Kenneth Copeland pulled a gun out on you and Detective Gaither?
yes,
Do you recall what your response was?
Objection has been asked and answered.
I sustain the objection.
Did he ever pull a gun out on y'all?
Objection has been asked and
Sustain the,
answered.
sustain the objection.
Now, all of the shootings that you and Detective Gaither and the gang unit investigated after the murder of Donna and Thomas, are you able to tell the jury why it is that you all were assigned those shootings?
That's been asked and answered.
I sustain the objection.
Did you investigate any of those shootings that you investigated after the murder of Donovan Thomas in any way different based on which group you felt committed the act that
no,
were alleged?
no,
Just one moment. You were asked about Mr. Copeland getting shot at in the earlier parts of January 2015. Do you remember that?
yes,
Was Mr. Copeland the only member of YSL getting shot at during that time?
no,
Did you make the same efforts to identify assailants when YSL was the victim as you did when YSL was the aggressor?
That's the improper false threat.
I sustain the objection.
Did you make equal efforts to identify assailants even when YSL was the
You
victim?
can object to the same question.
And I'll sustain the objection.
Shut up. the April 28, 2015 shooting at the home of Entrevia. You shook your head. After Entrevia Smith's home was shot at, did you tell the jury about media that she gave to you?
I'm not sure. But
Did she give you something?
yes,
What did she give you?
she gave me a video, social media post from Antonio Sledge and Quindarius Zachary, basically antagonizing Kelvin Watts in IFCAN.
And did you find that video of any value in your investigation?
Yes,
Did you utilize that video in any way to make, as Mr. Adams put it on cross, corroborate anything that someone had told you?
yes.
I'm going to object to that. I've never asked that question. This stage of the question.
I'll sustain the objection.
Do you remember Mr. Adams asking you whether or not you tried to verify what the streets were talking about?
Yes,
All right. Did you use that video in any way to verify things that the streets have been talking about?
I'm going to object improper mischaracterization of the question.
I'll sustain the objection.
All right. Did you utilize that video to further investigate crimes committed by YSL?
yes,
When you were given information during your investigation, did you attempt in any way to speak to other people about the information maybe one person had given?
I'm going to object as a vague other information.
I'll sustain the objection.
When you spoke with one member of YSL and that person gave you information, did you try to corroborate it with other members of YSL?
yes,
At times were you able to actually do that, corroborate?
yes.
Objection, Your Honor, hearsay.
Oh, sir.
Did you use the connections or the
Objection
compare?
to the leading question.
I haven't finished.
Objection to the leading question.
I'll wait, let me hear the question, Mr. Adams.
Did you use the shell casings collected in the drive-by shootings that we talked about to in any way corroborate information?
Yes,
Ms. Lovely's already testified about that. Can we move on to something else?
Yes, sir.
Okay.
Just one moment. Thank you, Your Honor, that's all I have.
Redirect, or we should say recross, Mr. Sharp.
Investigator Dennis, good afternoon.
good afternoon, Mr. Sharp.
All right.
We've been talking about a white truck. And you did not see one on April 25th.
Objection, asked and answered by Mr. Sharp.
I'll sustain the objection.
That's fine. Is it fair to say that you were confused about why I was asking about a white truck?
Objection, Your Honor, as to vague and improper questioning. You may be confused.
I'll sustain the objection, Mr. Swan. You can rephrase, sir.
Did you know why I was asking about a white truck? Yes.
Objection, relevance.
Sustain the objection.
You were involved in the investigation of the shooting?
Objection, asked and answered many times.
That's been asked and answered. Mr.
That's
Chair.
great, thank you. Are you not aware that Alvin Lewis, the bus driver, described two cars zooming by?
Objection, Your Honor, as to you testifying or telling the witness about testimony on another.
I'm gonna overrule the objection.
Are you not aware that Alvin Lewis, on the night of the shooting, described two cars driving by on the driver's side of the bus? One being,
Objection, Your Honor, mischaracterization of testimony.
I'll sustain the objection to form. You can rephrase the question, Mr. Sharp.
are you not aware that Alvin Lewis described a white truck driving by the bus at the time of the shooting?
Overrule, ma'am.
Are you not aware of that?
I wasn't aware of that, no.
Okay. And he also described a white sports car.
Who?
Are you aware of that, Mr. Alvin Lewis, the bus driver?
To my knowledge, yes.
We just watched a video, I believe it's 123E. I would ask, yes, actually, could you please, and you don't, just at the beginning, just pause it. No, I don't have to play it. I just want to- Okay, Investigator Dennis, that is my client, correct?
Yes.
Okay. Now, did you pull this video off the internet?
I don't recall. I just know that at some point I viewed it.
So you don't know who pulled this off the internet? Do you know when it was pulled off the internet?
It was pulled off during the time that we were this investigation.
Do you know a date?
I do not.
Do you have a police report indicating a date of when it was pulled?
I do not.
Do you have a police report indicating who pulled it off the internet?
I do not.
Okay, at balleralert.com, why is that on the bottom right of this video?
Because it was probably screen grabbed from balleralert.com.
So balleralert.com is a website that reposts things? Is that correct?
Yes,
How many people, is it a popular website in your opinion?
it is.
Okay, millions of people view balleralert.com?
Yes.
Okay, what about Repost Wiz app? Why is that there?
It probably was screen grabbed when it was pulled.
Okay, and in the beginning of this video, I don't believe it was played, but you're familiar with this video, correct?
Yes.
Doesn't it have something in the beginning, even before Mr. Stillwell comes on, that says college kids or something to that nature?
If you play it, I can see it.
Well, it's been edited out here.
Objection, Your Honor, we have that one, and it's not been edited out, there too.
So,
What's the base for the objection, ma'am?
The testimony that has been edited out that Mr. Sharp has made. So objection to the testimony of Mr. Sharp.
I'm gonna sustain the objection. Ladies and gentlemen, you disregard counsel's asked questions.
so we got a video. Oh, I'm sorry, Your Honor.
You can rephrase.
I'm sorry. We have a video. You don't know who posted the video, but you're recognizing my client in the video.
Yes.
Okay. And somehow it goes through Repost Wiz app and then ends up on Baller Alert where it's viewed by potentially millions of people.
Yes.
All right. Let's talk about the game. You're a fan of hip hop.
Yes.
Okay. Now, the game, as I understand, his government name is Jason Taylor. Do you know that to be a fact?
Don't know.
Okay. The game is a West Coast artist out of California, correct?
Yes.
Okay. The game, even in now we'll just say 2015. Again, we don't know when this was posted, but as of 2015, you would agree that the game was a very popular artist.
Yes.
Okay. Wins awards, known in the hip hop community.
I'm over the objection.
Wins awards, known in the hip hop community.
I sustain the objection.
Wins awards.
I don't know if he wins awards, but he's a popular artist.
Okay, known in the hip hop community.
Yes.
On videos, back when videos were on TV, the videos would actually be on TV, correct?
Yes.
MTV, BET.
Objection, Your Honor, vague as to what the question is.
I sustain the objection.
His music videos would be played on MTV, BET.
Objection compound and objection speculation. an objection foundation as to where and when any of this person's music videos.
I'm a sustained objection, Mr. Short.
Have you seen his videos, his music videos?
Him being who? Him being who, sir?
Game.
Have I seen his videos?
Yes.
Yes.
On TV?
Yes. Or social media or YouTube or whatever they.
The Game is not Dwayne Carter. Correct.
Objection, Your Honor.
Those are two different people, correct?
I withdraw that.
Okay, you can answer that question, sir.
Yes, two different people.
Okay. And The Game, I'm talking about April 25th, 2015, was not a concern of yours that night, correct?
Correct.
The Game was not performing at the compound, was it?
No.
He was not ever advertised to perform at the compound that night, correct?
No.
Yeah. You are aware, you said you're familiar with my client.
Yes.
You're aware that he, like many people in Atlanta, was an aspiring rapper, correct?
Correct.
Okay. You're aware that he would rent studio time, correct?
Objection, Your Honor, that would call for speculation. There's no foundation for
I
it.
sustain the objection.
This post that went to Repost Wiz app and then to this video that ended up on repostwiz.app and then went to
Objection, Your
Baller.
Honor, as to the characterization of this post being posted on repostwiz.app.
So what's your objection,
To
then?
that. So this characterization of testimony.
I sustain the objection.
This-
I'll sustain the objection on other grounds. Just go ahead.
This video that includes Repost Wiz app and at Baller Alert on it. Do you know how many millions of views this video received?
I don't.
Do you know how many millions of clicks on this video occurred?
Objection, Your Honor, as to the number and basis and foundation.
I'm asking if he knows.
I sustain the objection.
Are you aware of any other post that this aspiring rapper made that ever got nearly as many clicks as this
Objection,
video?
Your Honor, to vagueness, speculation,
I sustain
some
it.
specified
Are-
in
I
it.
sustain the objection.
Are you aware?
Objection, he's already sustained it.
Let him pose the question first, ma'am.
Are you aware of how many clicks this video received?
Objection, Your Honor, calls for speculation.
I'm asking if he's aware.
I
You
sustain
can
the
say no.
Calls for speculation.
Do you know of
I
any
sustain the
other?
objection already. Go ahead.
Do you know of any other video that this man has ever posted that's received this much attention?
Objection, that would assume facts not in
I
evidence.
sustain the objection.
Okay. The game's been to Atlanta since 2015, correct?
Objection, foundation.
I sustain the objection.
Do you know if the game's been to Atlanta since 2015?
Objection, relevance.
I'll rule that. You can answer, sir, if you.
I don't know.
Are you aware of any violence that ever came to the game in any visits to Atlanta?
Objection, Your Honor, foundation.
I sustain the objection.
Do you know of any violent acts that have been committed against the game in Atlanta?
Objection, foundation.
I sustain the objection.
I'm asking if he knows, Your Honor. If he doesn't know, he doesn't know.
Sir, you can answer that question.
Do you know of any violent acts that have fallen upon the game?
I'm aware of a post between the Game, Jimmy Winfrey, and I believe the basketball player OJ Mayo making a post about squashing the beef, but that was initiated by this said video. Yes.
Okay. Well, I'm going to ask you again. Are you aware of any acts of violence?
No.
Okay, thank you.
Anything else?
No, that's it.
All right, Mr. Adams?
Yes.
Let's get it, Dennis. Let me ask you a couple questions about these videos that we've been looking at. States Exhibit 118E. Remember that's the halftime video, all right? Remember that?
Okay. Yes.
All right. Remember when it was shown to you by the prosecutor a while ago and it had the words directed by BLB? Remember seeing that?
Yes.
All right, you know who that is?
A producer or a music producer.
Okay. Did you ever, after grabbing this video, where did you get this video from? Did you get it?
I don't believe so. I believe at some point I viewed it.
You viewed it?
Yes.
You weren't the one who got it?
No.
All right. Did you, in the course of this investigation that Ms. Love's been asking you about, speak to BB about the video?
I did not.
Okay. And you remember where it says, also directed by Jeffrey Williams?
Yes.
Who directed the video?
I guess the first person you said.
Anybody else?
I don't know.
You don't know?
I do not.
All right. Who produced it?
I do not know.
Were you present for any of the planning meetings for this particular music video for this?
That's not
But-
evidence.
Hold on. I stand objection.
All right. Do you know whether or not there were any planning meetings for this video?
Objection, foundation.
I will move the objection. You can answer that, sir.
I do not.
Okay. You know who the choreographer was?
I do not.
Do you know how many takes it took to do this video?
I do not.
Objection,
Do you know-
foundation,
Hold on.
and relevance.
I'll allow it.
Can you repeat the question?
Yeah. You know how many takes it took to do this particular video for this artist?
I do not.
Do you know whether there was anyone positioning people to stand in a certain location or do certain things during the course of the video?
I do not.
You were asked by the prosecutor about whether or not this music video, Halftime, was available publicly. Remember that question?
Yes,
You're familiar with the actual song, Halftime, right?
I am.
All right. Are you aware that this video is a video that was produced in conjunction with the song itself?
Yes,
And you were asked whether or not it was available publicly. So let me ask you, are you aware of music artists putting out music videos to their songs and keeping them private?
All right. Last I got was, are you aware of music artists putting out music, objection, relevance?
I'm gonna sustain the objection.
Okay. Are you aware of Jeffrey Williams putting out other music videos?
Other, objection, relevance, Your Honor?
I sustain the objection.
Okay. In your investigation, as you were pulling these videos and gathering this evidence, did it appear to you that these music videos were to be kept private for someone who's actually putting out music?
Objection, foundation, calls for speculation.
I sustain the objection.
How about the song Halftime itself? Was that song distributed to the public?
to my,
Objection, Your Honor, asked and answered.
That question has not been asked and answered.
I'll overrule it. You can answer it.
Was it distributed to the public?
yes,
In your experience, when an artist puts out music, do they normally put it out to the public for public consumption?
Folks, cannot talk at the same time.
Well, I'd ask to be allowed to finish my
Mr. Adams, I have
question.
told you, Mr. Adams, respectfully, I have told you, if an objection is posed, stop talking. Please.
I would object to my being interrupted simply so I can't ask the question. I'm allowed to ask
Okay,
a question.
and
If she has
you-
an
and-
objection, then she can interpose it then.
All right, so in the future, Ms. Love, wait till he finishes the question and then I'll pose, or before the witness answers, I'll make a ruling,
Your
okay?
Honor, it's the improper question.
The problem is that both of you can't talk at the same time because Ms. Weaver, she's great. She used to work she used to work at Congress, but because she takes down stuff that fast, but she cannot take simultaneous transactions. So don't do that.
And Your Honor, I would ask that the court, when there's an objection, make the court continue to try to stop the question because it's the improper question that I had to check.
I gotta listen to the question first to see, determine whether or not it's objectionable. Okay? So please do that
Yes, Your
in
Honor.
the future. All counsel going forward.
Yes, Your Honor.
All right.
And so, Your Honor, I still object to that question, the portion that he asked up until the point that the objection was made.
I'm gonna overrule the objection. Mr. Adams, you may proceed.
I don't even remember the question. As you were looking at and pulling these videos for the entertainer Jeffrey Williams, Young Thug, did you
Objection
pull
to the
other?
characterization, Your Honor?
He hasn't finished yet, Ms. Love. If you do that again, we're gonna have some problems.
Yes, Your Honor.
Do you know Jeffrey Williams to be an entertainer?
yes,
Do you know him to perform under the name Young Thug?
yes,
During the course of your investigation, you testified about this particular video that the state showed are there other videos that you also looked at and pulled? Other music videos from Mr. Williams?
You said, are there other videos?
Yes, did you, during the course of your investigation, pull other music videos from Mr. Williams?
Objection, Your Honor, they irrelevant.
I'm overrule the objection. You can answer, sir.
Yes,
I've
sir.
viewed other videos. I don't know necessarily pulled.
Were you able to either view or observe other videos where Mr. Williams makes reference to, in a positive manner, Mr. Dwayne Carter?
Your Honor, I object to the characterization, vagueness.
I'll sustain that objection.
On State's Exhibit 125E, that was the video that was, as a matter of fact, can I have prosecution put that video up, please? 125E.
Which section? The whole thing?
The whole thing, 1, 2, I believe, 31 seconds, the portion that the state played previously. If you're the one controlling, would you be kind enough to go ahead and play it now? I'll tell you when to stop, please. Go ahead. You can play it now. That's fine.
Yeah, YSL. Carter says coming out Friday, first show. New Orleans, Holly Grove. Fuck, nigga. Meet me there, better yet. Beat me there, you did. With them dicks, too. Yeah.
Stop it right there, please.
Can't name the mixtape Carter 6, cause these fuck ass niggas trying to sue.
All right. Would you agree that these are two different videos?
Yes.
Do you know what's taking place in the first one that we saw? What's taking place?
I'll sustain the objection.
Oh. Do you know who it is that stitched these two videos together?
I do not.
Okay. You agree, though, that they're two separate and distinct videos, is that right?
Yes.
And so do you know when the other one actually ends and when this one that we're looking at right now, when it begins?
I do not.
Would you agree with me that stitching these two videos together does not pose an accurate depiction of what is said in either one of the videos? Would you agree with that?
Objection, Your Honor, characterization.
I sustain the objection.
During the course of your investigation, who gets to choose whether or not you can cherry pick videos and stitch them together as a piece of evidence?
Your Honor, objection.
Basis.
As to vagueness and to the form of that
I
question.
sustain the objection.
Famous Atkins, you can take that down, please. Do you know when this album that we've been talking about, Carter 6 or Carter 6, whatever it is, when it was released?
I do not.
Did you have any conversations with the producers or directors or writers of that album, Carter 6? Any conversation with them?
No, sir.
Do you have any personal knowledge about this lawsuit that is referenced, that Mr. Williams references in that portion of the video?
I do not.
Who pulled that video where he's talking about supposed lawsuit? Did you do that?
I don't think so.
Okay. Do you know who did?
Possibly someone within our unit.
And then what? You gave it to the DA's office and said, hey, you can use this?
Yes, Your Honor, as the one relevant to compound and reform the question.
I stand the objection.
In the video that you were shown earlier that Mr. Shard was discussing with you, actually strike that.
It's not me.
Just making sure. We wrap this thing up. All right.
Sorry, Mr. Adams.
I'm glad it's not you. All right. Just the last couple of questions about this whole discussion about the group of people at the pound, right?
Mhm.
You were asking questions about 25 people. Remember that line of questioning.
Yes.
All right. When the prosecutor asked you whether or not these people, quote, moved together, am I correct? I hear you correctly that essentially what you were doing was dispersing a crowd of people.
Objection
Is that true?
asked and answered, Your Honor.
I must sustain the objection.
Do you know the names of the 25 people in that group of 25 people that we've been talking about?
Say that again.
Know the names of those 25 people?
I gave you the names of the people that I could identify, that I knew names of.
Right. And the other people, you don't know.
Not sure.
That's all I got. Thank you, sir.
Any other examiners? Yes, Mr. Matthews.
Investigator Dennis, good afternoon, sir.
Good afternoon. How are you?
I have a few questions for you. You recall holding up those two $100 notes?
Yes.
You testified earlier that Jimmy Winfrey offered you those currencies at the probation department, correct?
Yes.
Now, this was actually at the probation department of Mr. Jimmy Winfrey, correct?
Yes.
All right. And his probation officer was there that day, correct?
Yes.
You were there that day, correct?
Yes.
You didn't go inside and share that information with the probation officer, correct?
None of us went inside. We were outside.
Okay. You did not reference that particular alleged transaction in any case note that you prepared in connection with that investigation, correct?
No.
You did not recommend to the probation officer to draw up a petition to violate his probation for offering you a bribe, correct?
No.
You did not present to a local magistrate that you were offered a bribe by Jimmy Winfrey, correct?
No.
You did not seek out an arrest warrant, correct?
No.
You stated that you held on to those notes, but you never stated that Jimmy Winfrey asked for the money back or anything of that nature, correct?
No.
And on that particular date, Jimmy Winfrey did not mention the name of any other individual that's seated in this courtroom when those alleged monies were offered. Is that correct?
No.
He didn't indicate that it had anything to do with YSL, did he?
He just mentioned that he was acting up the other night.
Okay. He didn't indicate to you that he was offering those notes on behalf.
Let him finish his question. Is that your question?
He did not indicate to you, that is Jimmy Winfrey, he did not indicate to you that he was offering those notes to you on behalf of YSL, correct?
Basis.
Okay, here's it.
I sustain the objection.
That's all I have. Thank you, Your Honor.
All right, thank you, Mr. Matthews. Anyone else? Any other defense examiners? All right, anything further?
Not at this time, please.
All right, may retired Detective Dennis be permanently temporarily excused as a witness?
Temporarily.
All right, Detective Dennis, we're going to temporarily excuse you as a witness. Please don't discuss your testimony to anybody except the attorneys in this case. And we'll give you enough notice to when you need to come back if at all, okay?
All right.
All right, thank you, sir.
Thank you.
You may. All right, ladies and gentlemen, we have reached a time for today that, remember I told you we were going to leave anyways around between 4 o'clock. And so what I like to do is I talk with counsel, and given our next witness, we feel it prudent to start on Monday with that witness, okay? So what I like to do is to just recess you until that time. Remember, tomorrow we will not have any proceedings that you will need to be involved in. It's an administrative day for you all as a group. And you'll return on Monday for 8:30 for an anticipated 9 o'clock start time. So that'll be your, you'll be recalled for Monday. Then I'll go over on Monday, just to recap for you the rest of May. Okay. So that we're straight on those particular days. All right. Okay. All right. Any minister inquired me? Okay. All right, ladies and gentlemen, let's go through your ad nauseam admonitions. Remember, when you leave here, leave your notepads in the basket. Do not discuss the case amongst yourselves or in onesies and twosies or whatever small groups as you're going or leaving this place or coming back to this space from wherever it is you live within our great county. Do not listen to any media accounts, third-party accounts of this particular trial. Remember, the only thing you can properly consider is what is presented within the four walls of this courtroom. Remember, you're not to go to any third-party sites. You're not to augment your understanding and education by talking or otherwise referencing any other sites, because remember, you can only consider what's presented here. Also, do not go to any of the scenes that may have been depicted, you may have shown pictures as that would not be permissible or authorized. Also, as you're sitting back there in your headquarters, remember it will be a violation for you to recap or otherwise handicap the testimony by saying, hey, what do you think about such and such? Or speculate as to what we were doing out here. Remember, that's not authorized by you as a body. You can consider the case only when it's properly submitted to you, and the court gives you the appropriate instructions on how you're supposed to begin that process. All right, and then, ladies and gentlemen, if anybody, third party or otherwise, tries to reach out to you, you remember what your duty is to let myself and Sergeant Ingram know immediately that some type of contact has been attempted either via social media, be any others, emails or any other, or in person. But that would be your duty to tell us about that. And then thank you for your extreme patience that you've given us and will continue to give us through the resolution of this matter. Okay. All right. For those of you who are moms or grandmas or aunties and will celebrate Mother's Day this weekend, on behalf of all the parties here, I wish all of you and your families a happy Mother's Day. All right. Is there any minister inquiry you have of me? Okay. If not, we will see you on Monday at 8:30. Okay. All right. All rise. You slept enough. He's looking at me like, what's the deal? All right, ladies and gentlemen, please be seated. Our jury has left us. Okay, from our conversations at the bench, is it the state's intention to call Detective Racy next?
Yes.
Okay. First thing, is he going to testify on camera or off camera?
Just one moment. Oh, I think that he's going to be off camera. Getting confirmation because it's status. in law enforcement, sir,
Is he still employed as a law enforcement officer?
in the use of capacity.
He's an undercover. Any defense counsel wish to be heard about that issue? Mr. Harvey.
Is it on? Okay.
It's on.
I would object to him testifying off camera. I haven't heard any reason that suggests that the constitutional rights of an open trial should be curtailed.
Okay. Anyone else? All right, Mr. Harvey, I'm going to, over your objection, given the fact that he's an undercover officer, I'll permit him to testify in this open forum, but he just won't be videoed. He will still be audioed and otherwise. All right. Okay, what specific issues do we need to talk about in terms of, are there any videos or any other evidence that we need to the court needs to look at?
Judge, I don't think that there are, other than I think the one that Mr. Adams brought up, the third Jeffrey Williams video.
Is that one going to be shown through Detective Racy?
That one may be shown through Detective Racy.
All right, I'll need to take a look at that one. But what about any other videos or pictures or social media posts or anything like that?
There are other social media posts, Your Honor, if the court would permit me just one moment to look through our list of exhibits for those matters. Just 1 second.
All right.
As we are pulling the social media footage, Your Honor, I also wanted to make certain that the court is aware of the addition of 3 other, I think, jail calls from Jimmy Winfrey that we intended to introduce. But I also wanted to, if I can, just instruct everyone on the record how to access it without us having to convert them so that it's clear. You don't have to have extra stuff. I can tell everybody how to do that.
The last time that you did that, are you officer Tim? Okay. See how she sold you out that quick, Mr. Atkins? All right. Just want to point that out to you, right? Last time we had some challenges with that video conversion. So can we ensure that gets done so that everyone within the sound of my voice in this courtroom can go ahead and access that?
Yes.
And if they have a specific objections, they can be flagged?
Yes, it's not a conversion, but I'll do that all after, or I'll just sort of do a round table. And I'll also tell Mr. Kearns how to access it without it being converted with the media that you have.
How long are these 3 jail calls?
I think about 15 minutes each. We're converting them anyway, the 3 of them, but I still wanted to make the court aware.
It would be helpful if you did that so I could listen to them beforehand.
We're doing that. As a matter of fact, that is what is being worked on.
And when will that be done by?
We can have that by in the morning, Your Honor, if that's okay with the court, so that after.
In the morning by what time, madam?
11 o'clock.
Okay. All right, what else?
Your Honor, Ms. Hilton just informed me that
He being who?
he being Detective Racy, he does not mind being filmed, so we can withdraw the meeting, not have him on camera.
Okay, then, and you can let our media friends know as of who's ever here on Monday that he may be on camera. So that satisfies one issue. All right, and then so the 3 jail calls you're gonna make available, make sure everyone can play or give instructions
Yes,
by 11 o'clock tomorrow.
yes, we're gonna rip them before, yes, by 11 o'clock, and I will show everyone at the end of today how to play them without us converting them. I'm gonna give them to them before 11 o'clock tomorrow.
All right, okay. Anyone else?
About,
Racy.
yes.
Okay.
Sorry.
Okay. So the state may not, I don't know what they're going to do, but I certainly want to keep the smile on the court, the prepared court. So these are what I flagged, but if this is not what the state is doing with this witness, if they would just say that, then I could just move on. First thing is, it's July 15, 2015. Over objection, this honorable court is admitting a DeKalb County in custody statement to an ATF agent Cunningham and Detective Racy. Racy, I think, is R-A-I-C-C-I. Oh, SS, not CC, not Colette. SS. Samantha. I've asked for, I put in writing, I filed a motion, I could give you the date, but it was months ago. And I specified if the state's going to play it, obviously over objection, there are statements made about the search of Mr. Williams' home that has been suppressed.
I think we talked about that. Yeah, I suppressed those already.
Yes, but again, I know, the happy court.
A forewarned court is a happy court.
Okay, thank you.
All right.
I'm trying to, I've raised this a long time ago. So the state hasn't given me any type of redaction. I've given them what I believe. But if I'm wrong, I'm not trying to waive anything. It's not my recording. So I would like that if the state's going to play it. If they're not playing it, I'm going to move on to the next issue.
There's this custodial statement, less the statements or any statements made about the search of Mr. Williams' home. Is there going to be any other issues I need to take up?
No, Your Honor, there will be no.
Okay, so you've done the redaction?
So, Your Honor, 2 things. One, we don't know the court just denied the motion to suppress the statements. And we have.
I'd say that a long time ago.
Right, that's what I'm saying. Mr. Steele said that the court admitted over his objection. We're not saying that we're necessarily even playing the statement, but if we did, it would be with all of those redactions, and of course, we would give to counsel the copy of it before we even.
All right, let's just do that now so that there's not a problem, okay? Because look, it's better and for smooth of ease of presentation for them to have that redaction And if there's any objection to the redaction, or is there something else that needs to be redacted, which sometimes happens, things are, omitted, just accident, and that won't be a problem or an issue. So can we do that? Can you turn that over by tomorrow? Okay. All right. Okay. All right. Next.
Okay, so you ordered that all jail calls that the state intends to use at trial be given to us. We were given 2. Let me rephrase. We were given thousands of jail calls, but the state identified 2 that they shared Solomon Court and us. So on those 2 that we already have, one of them has Miss Diop, that's D-I-O-P, it's her last name. She's speaking with Mr. Winfrey. I'm objecting based upon hearsay. She's not a witness. I don't know if she's going to be a witness, but she's non-testifying. And I'm objecting to that jail call for that portion. On that same jail call, there's also a relative. I don't know who it is. It's a relative of Mr. Winfrey. I'm objecting to that part also because she, it's a woman, is not on that witness list to my knowledge. Now, look, I don't know who that person is. I just know that that person is not testifying, at least for the jail call. So I'm objecting under hearsay to these non-testifying people. There is a second jail call that we all heard, John, that was sent to you that involves Mr. Williams on the call. I'm going to object, but I understand that is Mr. Williams. So, I'm objecting just for the fact of 3, it's unnecessary, doesn't go to highlight anything. However, I understand the rule that I believe it's my client's voice and Mr. Winfrey's voice. So that portion I'm not objecting to in and of itself.
You just have a general objection to the phone call being admitted, period.
Yes.
Okay.
Then more specifically, any non-testifying party except my client.
Okay. All right. But that's the one that involves Mr. Winfrey and your client purportedly, right?
Small part. Other parts involve other people. It's more than my on the call. It's as if like.
So do you have objections to those non-testifying witnesses as well?
Yes. That's what I'm
Okay.
saying.
All right.
I'm objecting to all the non-testifying witnesses.
Okay. So let's do Winfrey call number 1, State. What about these non-testifying witnesses that that Mr. Steele's purported? Are they going to testify as part of your case in chief or the foundation for those calls, or what's your intent? Are you going to edit them out?
So, Your Honor, we're not, the calls that we'll be introducing through Detective Racy, and it will be Ms. Hilton that will be doing the examination. The calls that we will be introducing they come in through a number of exceptions, the statements that are not made by Defendant Williams.
What about the non-speaking witnesses that are not, or non-testifying witnesses, not non-speaking, the non-testifying witnesses? Of course, Mr. Winfrey, his statements would be admissible probably as a party opponent, but what about the other people that are there?
For context, Your Honor, under the rule of completeness, the conversation itself that is being had,
Still hearsay.
it would be admissible to completely, we're not using those who are the truth of the matter asserted, they would be being.
I know that, but but that they're still objectionable under that particular basis. So
If we could just,
we've covered this before.
we have. and
We've covered this before.
To pull up their calls themselves or to speak specifically about.
I listened to those calls. Remember, you gave them to me.
So, Your Honor, they are, it could be considered co-conspirator statements that are being offered for the effect. So when you get a response by Mr. Winfrey to something being said, Mr. Winfrey, for instance, if he asks someone to do something, to call someone, and the person responds, okay, whatever, and then Mr. Winfrey gives further instructions. Those statements, Your Honor, and I will pull up the statute before will use 1 second to do so. Those statements are so I'm gonna close the session. So in this particular call that we're talking about, Judge, as it stands today, we're looking only to get in Mr. Winfrey's words and in response to the request that he is making, that he be put on paper so that the police don't think this is some street shit at the end. So not the whole call. That includes other commentary, but the portion where he is instructing someone to do something for him. And their response to his instruction. And the fact that he made the request, and the fact that the response was given, not so much what the response is or the content of the response, but just that, for instance, put me on paper with YSL so they don't think this is some street shit. Okay, we'll do that. Not saying that they actually did, but the fact that it was conveyed. So that portion of the first
You
call.
want to give me the statute?
Oh, yes.
And how long is that particular portion of the call on call 1? Let's identify, what date and time was that call? So record can be clear for purposes of
Yes.
our discussion.
No.
All right, Ms. Love.
Okay, so Your Honor,
This is the first jail call, and what date and time, what date was it made?
June 28th,
Of what year?
2015.
Okay.
And.
And what do you purport to, which section do you want, how long is it in total? And then what section do you want to play?
In total, Your Honor, this call is. It's 30 minutes in total. And the portion, and the timestamp was, on the recordings is 15:58:02.
And to what date, to what time?
So it's time. So Judge, I'm giving the timestamps, but there's a portion in the middle and the last 2 minutes of the call that we intend to play. And so giving the timestamps of the portion in the middle is what I'm trying to get right now.
So you're gonna play from 15:58:02 particular section, skip and then go to another section?
So 15:58:02 is the time of the call itself. So from approximately 15 minutes into that call.
So what time is that?
That's what I'm trying to get right now. So Judge, for now, because we're trying to get the exact location of it, and we're still working on that, I would, ask the court to allow us to come back to the exact location. I would just have the authority for statements, and not all of them, not random statements that have nothing to do with what Mr. Winfrey is asking for and saying. But I would ask that the court allow me to just point to the authority that I was speaking of earlier for the inclusion of the statements that were not made by Mr. Winfrey.
Related to the call that the portion of this particular call that was made on June 28th, is that what you're asking me to, or to consider to admit?
Yes.
Yes?
Yeah, I'm asking.
Yeah, you're not asking me to omit, to admit the entirety of the tape, right?
Right. We're not
Okay.
asking to admit it.
You're asking me to admit a portion of that, a segmented portion, and this case law is relative to why that is admissible with other speakers?
Your Honor, yes, so actually,
Okay.
I would say that the case law is relative or relevant to why the entirety of the call would be admissible. And that case law, Your Honor, I'm actually reading out of my Carlson's Guide to Evidence Authentication. It relates to the statute 24 801 D2. The issue of whether a non-party statement.
24 dash what?
It starts out as, under 801 D2A, talking about a party opposing.
24 dash
statement.
what? Dash what? Dash 802. 24 dash 4 dash 802, what is it?
Oh, 801 D2A. And after addressing recorded conversations of a party opponent in 801 D2 Alpha, my guy goes on to say that the issue of whether a non-party statements uttered as part of a recorded conversation with a party opponent are admissible was addressed in a 2023 federal appellate decision. In that case, the defendant was charged with making numerous threats over the internet, and during a telephone call with his girlfriend, the defendant made incriminating concessions, juxtaposing the party admissions of the defendant with the introduction of the girlfriend's statement. The First Circuit Court of Appeals observed statements of a party opponent can thus be offered for their truth. Statements by declarants other than the party opponent can still be admitted in the context of 801 D2 evidence, where such statements are offered for a limited purpose, such as providing an explanation for the party opponent's portion of the conversation, but are not. So as to the call itself, the entirety of the first call that we're talking about, our position is that the statements by other people than Mr. Winfrey would not be being offered for the truth of their matter asserted, but rather for the context, to provide the listener, the jury, with the context for that call. And Judge, I'm looking in a smaller book than the one I normally look in. I can report my copy of the third edition of the Guide to Evidence Authentication. It's on my page 6. I'll give it to the court. Starts on page 6 and it goes into page 7 in section 1.05, recorded conversations and messages.
Okay, did you find out which section you'd like to admit, or you're asking the court to consider for admission?
The beginning of the call through,
Okay, you're talking about 5802?
yes,
To what time?
through 5 minutes in, and then at 7 minutes and 10 seconds in. So 1 minute to 5 minutes, and then 7 minutes. And then 7 minutes and 10 seconds in. Until I'm still getting the middle portion, but the very last portion are the last 30 seconds of the call, 30 minutes and 7 seconds in to 30 minutes and 37 seconds.
That's almost most of the call.
Your Honor?
That's almost most of the call.
No, the last.
The
30
last seven,
seconds.
no, the 7 minutes, 10 seconds to what time?
That
You
was-
said to the last 30 seconds of the call? That would,
Oh, okay.
that's what you said.
I'm
So that
sorry.
would be most of the call.
I misspoke.
Okay,
I was saying that the end portion of the 7 minute section, that was the portion I was trying to get, the end portion of that. So I was skipping, there were 3 sections. I said 1 to 5 minutes. And then the second section started at 7 minutes. I didn't yet have the last section of that middle.
so how long are you playing of the 7 minutes and 10 seconds? That section.
That's the portion that we're getting. Okay. Actually, skip that 7 minute portion. Go then to.
So you're not seeking the 7 minute, 10 second portion? What's the last portion you're seeking?
30 minutes and 7 seconds to 30 minutes and 37 seconds.
Okay. Okay, let me turn to call number 2. When was that made?
Call number 2 is June 13th, 2015 at approximately 17:39 hours. Approximately 5:39 p.m.
Which portions are you seeking to play? How long did that take? I think from our previous conversations, that tape is shorter. And I think I've got that information. Let's see.
Your Honor, just to further absolutely confuse things, I need to go back to the first call for a minute, for a second, and tell the court about the section in the middle, where I thought it was 7 minutes, 8:05 to 8:18 in the first call. time hacks for all of these calls, and we are trying to recover the drive that those are on. So, Your Honor, I would ask that the court allow us to either recapture those time hacks in the drive that we are trying to recover, or to allow us an opportunity via whatever mechanism the court prefers to send to both the court and the parties, rather than us listening to the whole 30-minute call here right now, to provide that to the court and the parties tomorrow by at the same time that we'll be the court on the other matters. As well, we can, if the court permits us, as to the very first one, we can play for the court the 3 sections that we were asking to be admitted now, and then provide the second call for tomorrow.
Are you talking about the call that's on June the 13th?
Yes.
Okay, well, remember, I've listened to the call, so I don't need to listen to them again. I just need to know the legal basis for admissibility. It appears that you've given me, or you fostered that at this point in time that United States versus Cantwell, F4th 396. Defendant's portion of the call came in under 801 D2 Alpha, and girlfriend's corresponding statements were admitted for limited purpose of contextualization. So, Mr. Steele or Mr. Sharp or anybody else, you have any other response to that? If it's for that limited purpose, or I believe Mr. Adams, or it may have been Mr. Adams that maybe mentioned that, but do you have any response to that in terms of the admissibility of if these are Mr. Winfrey's statements and he's talking to a third party, those statements can come in for contextualization?
Respectfully request the court to consider not admitting them. It is, and I need a case for you. But Mr. Winfrey is not a physical person here, so he's the party opponent. So I don't believe that 24-8-801D2A should apply. The context is, yes, that is the rule of completeness. It's also it's non-hearsay because it's just used for context. But here, the way my memory is, and I know the state has changed around numbers, so I don't know if I'm talking about the right conversation, but if it's Miss Diop, what I remember is Mr. Winfrey says something to the effect, I want to get on paper with YSL to make it look legitimate. That is not a quote, but it's something with that type of, I need that employment to be on paper. And Ms. Diop replies something to the effect of, I don't know about that, or we'll see, or I'll look into it. But that's very misleading, because then when I get up to cross-examine, I'm going to get an objection. I'm not saying you'll sustain it, but facts are not in evidence. The fact that there was no forthcoming YSL paperwork, Ms. Diop never acted on it. So the jurors just sit there and say, well, that's interesting. And the state is using Ms. Diop not to, supposed to just put in context. You don't need any context to put me on the YSL paperwork. They're using it for the truth of the matter asserted. I'll see what I can do. I'll see if I can do that. I don't know about that. Whatever the quotes are. So I need to see exactly the portions that the state is illuminating, but I do not believe that just because I'm speaking with someone and I am the person recorded and I'm the defendant, God forbid, not on trial, that my statements come in and the person who I'm speaking with come in.
Well, if it's statements of a party opponent, that's what it seems like that they come in for under 801 D2 Alpha.
If he's a party opponent at the trial, but I need to get your case. Could be wrong, but I think I think the opponent needs to be there. Like if he pled guilty to this case and was not here, let's just assume he's not a pending case because he's a pending case. Let's just, like Mr. Murphy. He pled guilty. Mr. Murphy's no longer an opponent. He resolved his case. So I'm not sure, and I need to look into it, but Mr. Winfrey's not here, so I'm not so sure that a party opponent applies to him. If it does, I'll let you know. I mean, I have to look up the law.
Okay.
But that's so I have two different bases. One, I'm not so sure a party opponent applies when Mr. Winfrey's not here, but I need to get law. Number two, the way I remember that recording, we don't need Ms. Diop's response because it will be misleading. And then, of course, yes, I can call Ms. Diop. I understand that.
But you don't have.
You've always told me. That's exactly what you've always told me.
Yeah.
You said, be careful because you don't have to do anything.
No, and
But it would be
that is
misleading
true.
at this point.
That's true. That's true.
So, Your Honor, in response, I would just point out that Mr. Winfrey remains a party opponent. His case is not resolved. He does not have to be physically present.
It doesn't make a difference if he's available or unavailable.
Right. It does not, like, he's a party opponent because we can't force him to testify.
But because
Yeah.
well, this is an exception to hearsay rule anyway. So it wouldn't make a difference whether he's
Right.
here or not, Mr. Steele. There are sections under where it does make a difference whether or not a party opponent is here, present and available when they're not. So since it's an exception, it doesn't make a difference. But you can look it up and let me know.
And additionally, in response to the second part of what Mr. Steele is, I believe that Mr. Winfrey is in fact talking to a person that he's calling Wheezy, and he's saying for that person to get in touch with Amina and to have her, Miss Amina, complete the paperwork so it doesn't look like street shit. And the person says, I'll see what I can do, or I'll try to do it, whatever it is that Mr. Steele is saying. But of course, the further information that he shared with the court about him asking facts that are not in evidence, that would be a separate matter that of course we would object to because we don't have any evidence that she did or didn't. We're not asking, we're not seeking to prove whether she did or didn't. We're seeking to show that there's a conspiracy, the existence of the conspiracy, and as part of it, Mr. Winfrey is saying to his friend, have Amina put me on paper so this doesn't look like some street shit. So that further proves count one of our indictment.
Who is Amina?
Amina Diop is a person listed. It's on the Secretary of State's website as one of the officials, one of the persons who have management in Mr. Williams' Young Stoner Life LLC. She's listed, I believe, as a manager. She's a listed officer. That's what I was looking for. She's a listed officer of Young Stoner Life. I believe she works with Mr. Williams in the capacity of the music portion of his business, as well as in hiring or bringing on his friends to work with him at YSL. So she's a manager or some officer with Mr. Williams' company.
Okay.
I think she's also been referred to as a manager by some of the witnesses, but I can't testify her state to the court. But she's his manager of what? She's just someone who acts on behalf of Mr. Williams.
Okay. All right. All right, Mr. Steele, I'll let you ponder that issue and I'll take it up. Depending upon how I rule, will depend upon the admissibility of these two phone calls. Okay.
Court, can you order the state, and if you didn't already do it, to give us the exact numbers again? I got very confused on the portions of that recording that they're seeking to admit.
They said they're gonna give it to you by tomorrow. at
Okay, with the
11.
numbers.
Tomorrow at 11.
Thank you.
Is that correct, Miss Love? Did I get that correct?
You got that right.
Okay, all right. All right. All right. Anything else?
I do, Your Honor. So the state announced today that they have 3 more, I think they said, I actually didn't hear it, but I've been told by Mr. Adams and Mr. Renard that the state has 3 additional, so there'll be 5.
That's correct. They said they were gonna convert or put them in a format that you can listen to them by 11 o'clock tomorrow. Ms. Love also said that she would, if you would remain, she would give you a tutorial on how to access those and play those immediately.
I will absolutely remain. But I'd ask the court to enforce your order dated November 17, 2023, where you ordered all jail calls to be given at that time in Stanter. Then we discussed this whenever you ordered the next set of jail calls, which was maybe last week. And you said the same thing. Yes, this should have been done going forward. It has to be done, but give now everything that's coming up. And we didn't have these 3 jail calls. So out of just your order, I would ask that any other jail calls be excluded based upon time limits.
Madam?
Your Honor, they've had the jail call since 2022, I believe. And what we've been doing all along, as we've said we would continue to do, is identifying them before we tender them so that if there is any issue with them, we can address it with the court. So we will be providing to them by 11 o'clock tomorrow for any calls that we intend to play in the upcoming week, the timestamps and the dates of the calls, so that if there's any issue, it can be brought up. But in terms of not complying, we have fully complied with what the court has directed in terms of giving them all the jail calls, unless there are some that, are made after that time.
Well, if there are any other jail calls that are unearthed as of this point in time.
Right.
They won't be admitted. They won't be admitted at this point, if you haven't otherwise turned them over already.
Right.
So, Mr. Steele, I'll take them up
If they don't.
as we have, because it seems like you have the universe of all the jail calls, but all of you have told me collectively as a group that there are thousands of calls. And what I'm going to ask the state to do, and that's why I wanted to kind of on a weekly or biweekly basis, figure out which calls are going to be made so we can go through this exercise. I don't have to do it when the witness is on the stand.
Right.
And I never said I didn't have thousands of jail calls, and I've reviewed thousands of jail calls.
Yeah, but it wasn't my intent to exclude anything else at this point.
Listen, I'm not here to argue. I'm just
I
reminding.
understand, but that's not what I intended to do.
This
sir.
is your order of 11/17/2003.
Yeah, that meant turn over all the jail calls that were outstanding at that point in time. You have the universe of jail calls. The only thing that I'm asking them, the state, to do at this point in time is to flag as we kind of go along those calls, so we can kind of deal with them.
Okay, listen, these are your orders, so you know what.
Yes, sir. So yes, sir.
This is what it reads, if you don't mind.
I do mind.
Okay.
I do mind, because we're not gonna parse out that. Just there, you have all the calls. Okay, let's just make sure that the state gives you what you need in a timely manner, so everyone can have benefit of that. You can make objections, and I can make rulings on that. All right, sir.
Understood.
Okay. Anything else?
Yes. So the state's not really saying what they're using Detective Racy. If we're done, then I'm done. But if they're using Detective Racy for any type of cellular telephone expertise.
Okay, well, let's find that out. What about Detective Racy and cellular telephone expertise?
Your Honor, as a part of his investigation, he was the lead detective in this case. And as a part of his investigation, well, let me say, as a part of his training as a law enforcement officer, he has learned how to plot cell phones. The state does not intend to introduce him as an expert, but we do intend for him to talk about what he did in his investigation. As a part of his investigation, at least for one or two of the phone numbers, he did plot those phone numbers to see where certain phones. It's not an expertise because he can talk about.
Is there some case law that says that distinguishes that issue? Because most of the time that I've heard testimony, the court has heard testimony about that. They've been qualified as an expert because it's outside the akin to the average person. I can't plot a telephone call, and I don't have specific knowledge about the carriers and directional issues and the like. So,
but he's been to training, Your Honor, which he can talk about the training that he's been to. He can talk about how he's been trained, and he can talk about what he did. Now, he will not go into as much detail as the azimuth and the three sides of the tower, but he can say, I went to courses, I know how to read the CDRs, and with that understanding, this is what I did. I then turned that information over to the experts to confirm what I did, but he specifically knows he's been to training, he's read the plots, he knows how to read CDRs, and what he did was he went into, I think he's gonna say, I went into Google, I put up the longitude and latitude, and I plotted it, but he's not gonna talk about the azimuth and the size of the towers. He's just gonna be able to say, this phone was at this location based on the longitude and latitude at this time, and this time. But he's not going to go into the full detail as our expert, Mr. Burney, will later on, because it's two different type of analysis. But what he did do is obtain cell phone records. He's had training on how to read those cell phone records, and he did plot the information based upon his understanding of reading the records. And he will talk about that training before the jury, so that the jury knows he's able to do it, and the foundation will be set that he's able to talk about it. But the state does not intend to go into more of the scientific aspect of towers with Detective Racy.
He has received 5 different specialized trainings in courses. This is just to show.
Yes, I have 3 items. First, I'd like to inquire if the court allows whose 2 jail phones are we talking about records being read?
whose cell phone records is he going to talk about?
Offhand, Your Honor, I know the one ends in 8556. And there's a few that he plotted, but I can say for sure. Excuse me, 8553.
8553.
Yes, the number ending in 8553,
Okay.
as well as the number ending in 3383. Those are 2 for sure that I know that he actually, like I said, figured out the longitude and latitude and put that in like a Google.
Okay.
Based on his understanding of reading the records and his training, and he had done it multiple times prior to this particular incident. And this is all in his report that he talks about, that he plotted these prior to giving them over to the data analyst. But in his report, he talks about him plotting these phones himself.
Your Honor, may I step out just for a moment, one minute to use the bathroom?
Yes, sir.
Thank you. I apologize.
Brown? Okay. Ms. Hill, I have taken a look at Moody versus the state. That's at 316 Georgia, 490. 490, 316 Georgia, 490. Moody versus the state. And my concern is, or the court's concern is, that it does fall into the category of expert testimony because it is based upon scientific, technical, or other specialized knowledge. So if you have some case, because this is what it says right in this particular case, Moody, you had two. Moody contends the prosecutor committed misconduct by eliciting from two Fulton County nurses and a former county jail officer improper medical opinion testimony designed to rebut his expert testimony. It says under OCGA 24-701 alpha, rule 701A, a lay witness may testify in the form of opinions or inferences that are rational based on the witness's perception, help a clear understanding of the determination of fact and issue, and not based on scientific, technical, or other specialized knowledge. So lay witnesses may draw on their professional experiences to guide their opinions without necessarily being treated as expert witnesses. But in the cell phone folks, that's technical or other specialized knowledge. And I mean, if you qualify for an expert, that's fine. I don't have an issue. Or you got another case which specifically says, hey, folks testifying about cell phone records or plotting. This isn't the first time this kind of evidence is being, evidence being elicited for, in trials. So if you got some other appellate opinion that would be informative to the court, I'll listen to it. But it looks like under Moody, citing Bullard versus the state 307 Georgia 482 at point 91, it would look like that it would fall under scientific, technical, or specialized knowledge.
Thank you, Your Honor. If we can have these next couple of days to look about some case law.
That's fine. And I'm saying if that does fall within that category, you could certainly qualify him as an expert, lay the foundation, attempt to qualify him as an expert, and the court will consider that accordingly.
Thank you, Your Honor.
Yes, Mr. Sharp.
Thank you, Your Honor. One additional concern that I had about Racy, Detective Racy's testimony. As part of this case, we were given ballistic reports, gunshot residue reports, other sorts of reports. Now, the state has not indicated that they're seeking to admit any of this scientific evidence through Racy. But if they are, similarly to how Mr. Steele just addressed the cell phone data, I'm going to be objecting to that. I think it falls under the case that you just cited, but also, Your Honor, it's a confrontation clause issue. And it falls under Bullcoming v. New Mexico, 564 U.S. 647, that's 2011. And that case basically said that scientific expert, you can't just call in another scientific expert who had nothing to do with the testing of the materials. And certainly under that reasoning, you can't just ask the lead detective what the results of some scientific tests were without bringing in the actual scientists who performed the test.
Well, without laying foundation as to that, because sometimes that evidence gets admitted independently and then it forms the foundation, because once it's the expert test or the technician testifies about that, say for example, it's ballistics or whatever else,
Well,
then of course you can testify.
and I don't know of the state planning to call any of these experts, so I'm just going to just say that I'm going to have an issue if they attempt to get into any of these scientific.
That'd be foundation, and you can certainly object accordingly. Okay.
What's that?
That would be foundation, and you could check. You could certainly object accordingly. Okay.
Okay, I just wanted to flag that for Your Honor.
All right. Okay. Anything else,
No.
Mr. Steele?
Your Honor, and again, I don't know. Again, I
I don't know if this is an issue, but if the state tries to seek the admission of Mr. Winfrey's certified copy of his guilty plea in Cobb County through this witness, I have concerns, especially with this, because as the court already ordered, but I did not see it, the state is ordered to redact and let us review and then present to the honorable court Mr. Williams' name from the indictment. I would ask the indictment not go back. And again,
Well, we deal with that later, but has the redaction occurred?
not to my knowledge.
Your Honor, there was,
Yeah, I'm sorry.
Your Honor, there are two things that I needed to point out to the court. One, the line of questioning of Mr. Lewis by Mr. Adams related completely as to why it is that Mr. Lewis would be suing Jeffrey Williams and YSL when neither of them, or at least not Mr. Williams, was alleged to have been anywhere. So by asking those kind of questions, I know that we approached the bench at some point.
And I still have not, I won't admit those.
So, right, so we let Mr. Lewis, we didn't ask anything about that. But in terms of the Mr. Williams' name being listed in the indictment, the court has ordered until the court hears further argument or further elucidation on the point that we do certain redactions. We are not intending to put up anything in front of this jury without putting it in front of the court first and letting it be known. So even if we tender a copy of Mr. Winfrey's certified conviction, we would not be publishing that conviction for the jury with anything on it that the court has told us to redact, period.
Yeah, we've covered that already, yes. So it goes without saying. There's going to be a testimony about Mr. Williams, right, from Cobb County?
No,
Okay.
no, it would not, wait, to be clear, when you say from Cobb County.
Cobb County, yes.
Ms. Hilton is, she's pulling my coattail, but Your Honor, the point that I'm making is we won't be referencing his name in that indictment
Okay.
with this witness.
All right.
That's what I mean.
There
when
may
I
be
say
other
that.
reasons and other
Yes,
independent bases
yes.
that may be relevant and admissible, but I'll take that up. I'll cross that bridge when I get to it.
And then
Where's Matt?
the informed court is the happy court. I don't know, it started out at the bench where I said it would be best if the state can outline their topics with this witness so we can target it, because when that didn't happen last time, I didn't realize that the state was going to play a certain exhibit, and then the court got upset and said, why didn't you miss this beforehand? So that's the issue.
That was different. That was different because you raised that on a Friday. And again, we took it up. We didn't take it up because, Mr. Steele, you are a very esteemed advocate, but had you mentioned something Monday morning, say, hey, I sent you an email over the weekend. You see that? And it says this, and we really need to take that up before our witness goes on the stand. That was that issue. So I'm just asking you if there's anything else that we need to take up. Certainly I'll consider it, but it just needs to be timely. That's all.
If it was my witness, I could tell you exactly, but the state's not giving the roadmap. So I'm just trying to tell you that those are the items that I have targeted.
Okay, but what's in terms of this fourth thing, what do you believe that the state is going to get into that? I mean, because all of you, this is not your first rodeo. Is there any other area you believe the state, just like you've been doing right now, you believe the state's going to get into that you need to ask me about?
I don't know. I think I raised everything, I guess.
Okay, all right. So you got, okay. I mean, I don't think that the state should be required to give you the roadmap of their examination. I wouldn't do that for you. I mean, but
Yes, you would. Could you tell me if you could beat me? Here you go.
well, that's me as an advocate. But but anyways, so we'll cover the jail calls on Monday. We'll cover the the state will identify and flag those to you. I've heard the case of Cantwell already. So I need you all to hear them if there's any further objection. Number two is the detective or officer Racy's cell phone discussions without being qualified as an expert under Moody versus the state, 316 Georgia, 490. The state says they'll research that issue to see if that is proper for him to testify as a lay witness in that respect. 3 is the Mr. Winfrey's certified copy, which has Mr. Williams' name redacted out of it, if the state introduces it in terms of discussion, that will be the only thing that they did. They don't talk about Mr. Williams in this particular document. I have said that Mr. Williams, and maybe reference at another times, given the foundation, subject to a foundation and subject to other additional rulings. So is there anything else, Mr. Steele, at this point?
I know you were looking for another one. It was the July 15, 2015 in custody statement. That was when you
July 15, 2015 in custody statement.
Yes,
I think we covered that already. You indicated that there were references to Mr. Williams' search that I've excluded.
Right.
The state has said they've already redacted that, and I don't know whether or not they're going to use that particular statement.
Right. They did not, to my knowledge, share the redaction. I know they didn't share redaction with me, so I can't listen to it. But yes, they said they're not sure they're going to.
Did you all share the redaction with Mr. Steele?
That's what I just talked about earlier, that I was using him, the redacted copy.
By today or by tomorrow?
And that's what I said.
Okay.
Redacted that portion out and provided to them by tomorrow.
Okay. All right. All right.
And then because Detective Racy knows about the search of the home, the court can order the prosecution to remind.
That goes without saying. That would be improper because that. Yes. Just make sure that you cover that with him, because I don't want to hear that. Because I've said that like 4 or 5 times already about excluding that particular search. Okay, the one on July 15th of 2015. All right.
Right. We have.
Okay.
That's not an issue.
Just make sure witnesses get sometimes run afoul. So please, before he comes on the stand, you need to let him know, hey, do not mention anything about the search of Mr. Williams' home in any way. Okay? All right. Okay. Anything else?
Those are the only things I can think of.
Good.
Without knowing what the state intends, and they're not revealing their hand, and the court's not requiring it. So that's what I have.
Okay, sir.
But if we approach the bench and you tell me why don't you tell it, because I can't anticipate anything.
Well, that would be that, Mr. Steele. I mean, I can't fault you for that, but I do believe you all as seasoned advocates flag or anticipate 97% of what will be covered. It should be no secret to any of you. And again, as a court has acknowledged and referenced, and will continue to reference, that the state bears the burden at this point in time, and the defense does not present anything. So at this, this will be helpful because we won't have to spend an hour and 15 minutes in front of our jurors taking this out.
Then will we get the update on the witnesses to come if they change from what we last had by Friday again, even though we're not all together?
Yes, sir. We will provide that tomorrow
Okay.
as well.
All right. All right, folks. I'll see you on Monday, okay? All right. Happy Mother's Day to you, all of you, and your families, and your moms, grandmas, aunties, and sisters. Okay. All right.